I wish to render myself with regard to the application for the respondent to be granted.
On our part, Your Honor, we are ready to make an application for I'm duly informed by the IO that although the 14 days were granted, there is need to have the custodial days extended for reasons You know, the application is notice of motion dated today, the 1st of December 2025, supported by an affidavit by number 239689, Inspector of Police Kevin Kasango of the ATPA. So we are ready to present our arguments in respect to the application, Your Honor.
Yes.
Your Honor, the said application for extension is predicated upon Section 33, subsection 8, subsection 9, subsection 10 of Porter,
Section 33,
8, 9 and 10, as well as Section 34, 35 of Porter, Prevention of Terrorism Act, Cap 59B, Laws of Kenya. You know, the reason are contained by the custodian of fact, Inspector Kevin Kasango, through his affidavit of 11 paragraphs. And to summarize the application is to inform the court that after the 14 days were granted, investigations commenced, and going straight to paragraph 4 of the notice of motion, under a miscellaneous application number E590 of 2025, such warrant orders were granted via an application dated 14th of November 2025 for digital forensic exploitation of gadgets recovered from the respondent contained at paragraph number 3 of the said notice of motion. As properly submitted by the lead counsel, the respondent underwent 2 interviews but still the investigations were not complete, and therefore under paragraph number 4 and 5, the respondent refused to cooperate in the course of investigations, which rendered the digital forensic exploitation orders issued by the court on the 19th of November this year impossible or difficult to implement. Your Honor, through the affidavit in support, at paragraph number 7, 8, 9, 10, and 11 details the extent of investigations that were had during the time the respondent was in custody, and also presents to this court the challenges the investigators have faced, which made it impossible for them to properly utilize to completion the investigations on the dates given. It is therefore based on that they request you to increase the said custodial days for another 15 days for the following reasons. The respondent at paragraph number 8 is stated by the custodian of facts to have refused, Your Honor, to give out his passwords, and therefore the implementation of the court orders issued on 19th of November 2025 was delayed to the larger extent and hence, as we appear to you today, the investigations remains incomplete as a result of that. At paragraph number 9, the custodian of facts indicates that the respondent's custodial orders needs to be extended to enable them receive the forensic exploitation report to enable them conduct further interviews and forward a complete file to the DPP for the making of the decision to charge in respect.
To charge or not to charge?
Decision to charge means, Your Honor, either charging or not charging. It's still a decision to charge. In respect, Your Honor, the decision to charge in respect to the evidence, and hence it is just and fair that the order sought be granted. At paragraph number 10, Your Honor, you are told the investigations team has so far received a Binance report during that period, confirming that indeed the respondent received money from a designated terrorist entity, and subsequent to that report, the officers have obtained search warrants and obtained M-Pesa statements for one of the numbers mentioned in the previous application belonging to the respondent. But the other number, the statements are yet to be supplied. At paragraph number 11, the multi-agency interview, the investigating officer owns up that it was conducted but not complete, since the mobile phone is yet to be exploited due to the respondent's refusal to cooperate with investigators, and hence the need for this application that was necessitated by the respondent's
Your
own conduct.
Your Honor, may I say that it would not be.
I'm not done. And hence the need for this application was necessitated by the respondent's own conduct. Your Honor, going to Section 34 of Prevention of Terrorism Act, Cap 59B, Laws of Kenya, the said provision provides for power to gather information. Your Honor, the said provision states that where it is believed by the court that reasonable grounds to believe that an offense under Porter has been committed, the power to gather information is granted to the investigators. And Your Honor, at B, all you need to show is that there are reasonable grounds to believe that an offense is likely to be committed, or a person has direct and material information that relates to the commission of an offense. And 34B3, reasonable attempts have been made to obtain the information referred to paragraph 2 from the suspect. Based on that provision, Your Honor, this court is mandated under the terrorism laws, anti-terrorism laws, to ensure that investigations are completed in respect to a respondent whose mobile phone has been linked to receiving money from a designated entity, and the said respondent has refused to comply. Your Honor, you will be told by the defense counsel that there is a right called right against self-incrimination. But that right is under Article 50 of the Constitution.
49.
Your Honor, I don't know why Mr. Machira is
finish my
speaking for us.
submissions.
Yeah, I don't know why Mr. Machira is speaking for us. Let him speak for the state.
Let's allow the state to conclude. That way, then we will be able to utilize our time properly. The interruptions will only cause delay. So please, let's allow them to conclude. We have our opportunity to respond.
Your
Your
Honor,
Honor, the problem with Mr. Machira is he's speaking for us and he's also misrepresenting the position we would take.
And therefore,
We will not even take the position of self-incrimination.
The right point at which you can respond and clarify all the issues raised by Mr. Machira is at the point when you have the floor and you are able to recall and to remind the court what the state has said and to set out the correct position. By interjecting and asking him to correct on the spot, even the recording of the proceedings will become difficult.
If the court may allow me, Mr. Murithi, we are of the consensus on the defense desk that we abide by what the court is saying. Let him finish, and then we come on all those issues. Just to save time.
Yes.
Yeah.
Your Honor, I was at the right against self-incrimination does not arise when it comes to this kind of investigations. Under Article 49 and 50 of the Constitution, Your Honor, the state is aware of the provisions of the said two rights or fundamental rights contained therein. But remember, Your Honor, the Constitution of Kenya is a Constitution of Kenya that was passed in the year 2010, August 27, the date of promulgation. Thereafter, in the year 2012, the drafters of Prevention of Terrorism Act, bearing in mind the provisions of Article 49 and 50 of the Constitution, passed a law, Cap 59B, and required for the procedures in dealing with suspects, Your Honor, of terrorism. And that is how Section 34B(3) comes in to give a right to require information from a suspect, even where their suspect has been requested severally to give that information, and reasonable attempts have been made but frustrated. Going back to Section 33 of Porter, paragraph 8, 9, and 10, the law then requires that an extension of days previously granted to be allowed in counterterrorism investigations in such kind of a scenario that I've mentioned herein for up to 360 days to ensure the investigations are complete. So as the court retires to make its ruling, we request the court to look at Section 34 of Porter on the power to gather information, bearing in mind that that information is in a gadget. That information has linked the respondent receiving money from a designated person in a gadget that he has refused to give the passwords to. And therefore, the right to self-incrimination cannot be a defense under Section 34, under Section 33 of Prevention of Terrorism Act. In fact, for you to give the dates, Your Honor, extension, Section 33 requires that you are told what has been done and what remains to be done. And based on that, we are saying what remains to be done is forensic exploitation. When we were submitting before you previously, we were requesting, or we were in fact looking for 20 days. The counsel who submitted, they all said that Mr. Chacha Mwita was working, and that is on record, with investigators, and he is cooperating. But this affidavit now tells this court that is not indeed true. If he would have cooperated, the issue would have taken a lesser time. But now he hasn't. And the investigations are not complete. So in the circumstances, Your Honor, we kindly request you to find that indeed a reasonable investigative process has undergone through the 14 days that were granted, and the exploitation remains undone. And subsequent to the exploitation, the investigators are telling you that they need to re-interview based on what will be found on that form. Re-interview the terrorist suspect. For that reason, and without regurgitating, Your Honor, what the affidavit says, we pray that you allow this application. It has two prayers. One is the extension of days at the same facility for 15 days out of the 360 provided for by the law. And secondly, the respondent be compelled to give out passwords for the electronic gadgets Your Honor listed at order number 3, paragraph 1 to 4. So we so pray, Your Honor. Just a minute, Senior Counsel. And also the court to consider that any arguments on constitutionality of this application cannot in any way be made in contravention of Article 24 of the Constitution, where it says that all these rights may be limited pursuant to the said Article 24 of the Constitution, as read with Section 35 of Prevention of Terrorism Act, and the said Prevention of Terrorism Act has not been rendered unconstitutional at any stage in Kenya. So we so apply, Your Honor. The application is made in good faith, Your Honor, and should he cooperate, then it can take even 2-3 days. But if not, Your Honor, we request for the full
365.
15 to enable the investigators maybe use alternative methods to get that information.